Welcome everyone, it's Monday, and today I have two special guests. Beth DeBaptiste from Star Title. She is Vice President and in-house counsel for Star Title, and she's on my right, and Eileen LaPlante is on my far right, the Vice President of Star Title. And so we're going to ask them some, to tell us some horror stories about title work. But to get this party started, I'll begin by saying I learned over the weekend from Greg that apparently there was at least an attempt, if not successful, I'm not 100% sure on that, to steal a house using a quitclaim deed. Now, if you watch my program very often, you will hear me say and see my posts on Facebook Connect that do not rely on a quitclaim deed to transfer title. They are very dangerous to rely on. And in this particular case, it's my understanding, we're still trying to piece this all together, that a fraudulent quitclaim deed was used to sell it to an unwitting buyer. They closed and the money was either dispersed or very close to being dispersed. Again, I don't have all the details on it, but what I want to do is see if I can turn to Beth and Eileen and explain to me how that might happen in real life. You mentioned something, Beth, earlier about snowbirds that go off to Florida, for example. How might their neighbors, steal their property essentially and sell it under a quitclaim deed?
Well, you have to remember that fraudsters are fraudsters for a reason. They know what they're looking for, and they know how to tap into that resource, which means that they have most likely investigated the title on that property to know that there's equity in that property to be made. And so if someone can go in and act as the seller of the property, as we would call a straw seller, and potentially there be a straw buyer, so that that buyer can go in, get a mortgage, get proceeds to pay off the seller, and you find someone who will insure that transaction, that's a recipe for disaster.
Yeah, and when you're saying insure that transaction, you're talking about title work.
Title insurance. Correct.
So that's why we have these Eileen and Beth here today, because we want to talk about the importance of title work. And there's one really, really good example of a situation where a straw buyer went in and created a fraudulent quitclaim deed, found a title insurance company to insure the transaction, and essentially stole the house from their neighbor or whomever it was. So again, I don't have all the details on it, but it's very important that when you're involved in a transaction that involves a quitclaim deed, you want to investigate that very thoroughly. You want to be sure to read the Schedule B and understand it thoroughly in order to protect your buyer and your seller. Now, Beth, you mentioned also to me a situation where a property had changed hands numerous times, 5 or 6 or 7 or more, whatever it was, but it had changed hands numerous times with quitclaim deeds. Can you give us a couple of examples of how that could create a problem when you get to that last person who supposedly owns the property via a quitclaim deed? But for example, up here, when Uncle Harry owned it, he had a wife who may have had some interest in that property. There are a lot of scenarios I can see just on the surface,
Right.
but maybe you can explain them more fully.
Sure. So when you have quitclaim deeds in the chain of title, that means they are uninsured, which means that you don't have a title policy in all likelihood as it relates to any one of those transactions. So that means that there has been no one tracking, following, checking any of those transactions to make sure that they were valid and legitimate. So the saying goes in the industry, a quitclaim deed is only so good as what you own. So if I sign a quitclaim deed but own nothing in that property, I give you nothing. And so if our practice is at Star Title, if there are if there are quitclaim deeds within the last 5 years appearing in the chain of title, we will include a special requirement to further inquire and ask about that transaction. I think the example that I was giving you earlier, Don, was that we had a situation where I've seen it more than once, where you have a quitclaim deed, but it actually recites consideration for $5,000 or $10,000. And you look at that and you think, wait a minute, there's something more going on, and it's a handwritten deed, which calls into question even more questions as to, well, wait a minute, that was the owner of the property. Why would she willingly sign over this property
That's so much less than it's worth.
that's showing on BSNA or Zillow that it's worth $100,000, but she's willing to give a deed for $10,000? What's going on here? So in that situation, we will ask for further documentation. Well, was there a purchase agreement? I'd like to see the purchase agreement. Did she actually receive $10,000? Do you have proof of that? Perhaps we'd like to see that as well. So it depends on any given scenario what we might be asking. Sometimes it's a matter of checking out the notary. Is that notary someone
Real.
who
Are
is
they
real?
truly a notary?
Or is their notary expired? Are they involved in some sort of scheme?
Eileen, I heard you mention something about this $5,000 or $10,000, whatever it was, to be so much less than the real market value of the property. And why would somebody do that? And I guess that calls into question for me, why would they do that? Was this intended to be a second mortgage, or was this somebody who was not the seller, who was no longer mentally competent?
You've got a lot of different elder abuse, straight up fraud. There's a whole lot of things that could happen, and that's why we do so much more due diligence on these types of situations, because we want to know why Grandma Jones only got $10,000 for a house worth $100,000.
Would that, in that kind of a situation, would there be maybe a tip-off to, by seeing who was selling it, and if whether or not that person might be related in some way, whether a relative or a neighbor or something, where that person knew that owner's mental well-being, let's say.
Yes, exactly.
For example. Okay. So, bottom line, quitclaim deed is very often recommended as an easy way to transfer ownership, but be very, very careful. We have several instances right here that we can point to that it's not the best choice, and it may turn out to be fraudulent. It may turn out that there may be other interests involved, as Eileen mentioned, that have not been adequately paid or paid anything at all. So if you go down that road, make sure that you have title work involved and have it insured. And in that process, I would hope that whatever title company you use would investigate that more fully.
The timing and the speed are very important too. If all these transactions happen very quickly and there's a rush, there could be issues.
Okay, so it's a little bit of a red flag if it's happening really fast. It tends to suggest that maybe they're trying to push something through before somebody catches them.
Yes, they want to get the money and get out of
Okay,
town.
and we have our every afternoon fire department visit. We'll hold for. Thank you, gentlemen. Thank you for your service and your lovely siren. So, moving on. Let's talk a little bit about LLCs. I know a lot of agents sell properties where an LLC is involved. And then we're going to spin off a little bit and talk about probate, trust, and power of attorney. All ways that property can be transferred. But I'm going to start with the LLC. Actually, I'm not. Beth is going to start with the LLC, because I know a lot of agents pushback when they get requirements for documents for a closing regarding an LLC. So with that, I'm going to turn it over to Beth and let her have at it.
Yeah, thanks, Don. Yeah, so there are a couple situations that come to mind. First situation is our title agency hasn't done business with you before, and so we don't know this entity from the next entity. So we want to make sure that we have the organizational documents and the operational documents for that particular entity. So for the operational document, that would be more your I should say for the organizational documents, that would be more your articles of organization that you oftentimes see filed with on the LARA website on the state. And then the operational documents will be your operating agreement, any amendments to that operating agreement, any consent resolutions or things of that nature that may have changed who the members are, how they do business, who the managers are, if there are managers. So once we have that documentation, then we can see, what are the powers that are given to the parties who own that organization or that entity. And secondly, who has the authority to sign for that entity? Oftentimes, most frequently, and probably what's most familiar with most people is that you'll have a single member LLC, and oftentimes those type of entities won't even have any organizational or operational documents. So that we then have to treat a little bit differently. But for the most part, we want to make sure how that entity is organized. Are they operating as members? Are they operating as manager or managers? And what authority do those respective parties have to sign certain documents? So once we have those, we have a repository where we collect those documents and we keep those on hand, so the next time we shouldn't have to ask those questions. So the important part of that, Don, is that if you have, for instance, let's say we have an LLC that is run by managers, and that manager has the authority to sign all the documentation that's needed to sell a piece of property. But then we actually have a deed that is not signed by the manager, but it's actually signed by a member. But the member didn't have that authority, or there are two members, and those two members, to give the manager authority, actually needed to sign a resolution to give that manager the authority for that particular transaction. But what if we don't have those? Well, that means that the members could unwind or attempt to void that transaction, which could result in a total title failure. The second part of that is that, unfortunately, we go back to fraud once and once again, that there could be entity hijacking. That means that we have someone coming in pretending that they are that LLC. They file new paperwork with the state saying that, this person is now changed. The manager is no longer that. The manager is now this, and this person has the authority to do this. And unwittingly, again, that LLC sells a piece of property. They're not the person. They're not the people who own that LLC, and they walk away with money, and in the whole scheme of things have sold your property to someone else. So we have to be very savvy about who our seller is, if there have been recent changes to any of those LLC documents. So on the title end, we are doing so much more due diligence than may be than folks may be aware of at first glance. We're doing a lot of behind the scenes to check to make sure these people are who they say they are, that this is a legitimate, genuine transaction, so that you can be assured that your buyer is actually going to receive good title to that property, along with an owner's policy of title insurance.
What likelihood is, let's say, for example, in an LLC, somebody essentially spoofs the LLC, like you see people spoofing on Facebook, but they spoof the LLC, sell somebody's property, and walk away. What's the likelihood of the real owner actually getting their money back and essentially reversing the transaction, or getting their funds back after that kind of a sale has closed?
Is that something you want to speak to?
Litigation?
Litigation,
Yeah,
lawyers.
I don't know. I don't see a happy ending to that story
Yeah.
for anyone.
And nobody's happy.
Right.
Not just the people who lost. The buyers aren't happy, the realtors aren't
Right.
happy, the title
Yeah.
insurance company isn't happy.
Yeah,
There's nobody gonna be happy
basically,
there.
Everybody loses except the one who spoofed the account.
Exactly.
Spoofed the LLC in that particular case.
Even if the original seller is made whole, he still had to go through this ordeal, and
Yeah.
it's not gonna be fun.
And probably hasn't been paid the attorney fees that he paid out.
True.
So, I want to shift from there. So, when you get requests from title people regarding LLC documentation, this is why. This is the reason that you're hearing right here.
It's for everyone's protection.
It's for everybody's protection. Same goes for things probate, trust, and power of attorney. First one, Eileen, power of attorney. See how we cut that out?
I like that.
It was like, it's not even there anymore.
Very nice.
Yeah. Probate. Letter of authority and deed from the estate are two essentials in a probate situation. Now, correct me if I'm wrong, but if property, before it can be sold, has to go to probate to establish who are the potential heirs for that property if the homeowner does not have a will. Is that, or a trust, is that
It
correct?
can go in both situations.
In both situations?
Yes.
Okay. Help me understand that one.
If a person has a will, their wishes tend to supersede. If a person dies without a will, then there's a statutory chain of succession, I guess, if you will, as to who is entitled to the assets of that person's estate.
Okay.
And the court would determine that.
So it could be, if I'm hearing you, if somebody dies without a will, the children of the homeowner may have a right.
Spouse, children, and it
And
reaches out from there depending on.
And what about if there was an ex-spouse or the children have married and remarried? Then it starts to get a little bit iffy.
And that's exactly what the court is there to determine,
Yeah.
who is actually entitled.
So the person who is going to file the paperwork to open the estate is oftentimes the person who's asking to be appointed the personal representative of that estate. And they have to fill out paperwork. And the paperwork that I oftentimes will ask to see is called the testimony of heirs. And also the application or the petition to open the probate itself will actually ask that you list out who the heirs are if you as the PR are related to the deceased person and what that relationship is. When we start to really get concerned is when we are looking at the chain of title and we see that the personal representative deeded that property to themselves individually. So they would deed out as the personal representative of the estate of the decedent, sign in that capacity on the deed, and then give that property to themselves individually. So in our speak, we call that a self-serving deed, and we have to ask questions. Was that something, if there was a will, did the will provide for that? If there was a will, was there only one beneficiary, or were there multiple beneficiaries or heirs? Or was there, if there were multiple heirs, but only the one person got that interest in the property, maybe then we need to get consents from the rest of the heirs saying, oh, we agreed to that, not a problem. And sometimes we'll see that, but we need to make sure at the title company end that, again, that person had the authority that they, what looks like on title that they did have. And so the other part of that is the letters of authority. We actually look to see, were there letters of authority given by the court to that particular personal representative saying you have the authority to sell this property? So most oftentimes what we see are unrestricted letters of authority. If there are restrictions that are placed on that personal representative, they will be written into or typed out on the letter of authority form saying, most oftentimes we'll see something to the effect of, there's no authority to sell any real property without a prior court order to that effect. in which case we would then look for an order from the court directing how that particular property is to be sold. So, but that's most oftentimes what we encounter with a probate situation.
Speaking of orders from the court, we have divorce decrees, and I had a property listed years ago, and had the divorce decree from which had occurred several years prior, and it awarded the property to the husband who had built the property prior to their marriage. And when it came down to the last days before the closing, the title company called me and said, we need Mrs. Smith to quit claim her interest in the property to the seller. And I said, well, Mrs. Smith already did. It's in the divorce decree from 3 years ago, and I gave that all to you. And the title person said, no, not that Mrs. Smith, the other Mrs. Smith. And apparently he had spent a weekend in Vegas and ended up in a wedding chapel, with an Elvis impersonator. And sure enough, 6 months later, he was trying to sell his house, and she was on record as his wife, and they couldn't find her. They had to hire a skip tracer and basically hunt her down. And when they did find her, she said, oh, sure, I'll be happy to sign off for $15,000. Just write me the check, and so on. And so that's, one of my personal horror stories of title work and what can happen. We did have the divorce decree from the first wife, but not the one from the Elvis chapel. So anyway.
Well, and to your point, divorces, there's no one that's alike. They're all different. And so as much as you have folks who might not want to turn over their divorce paperwork, it really is important to look at it. And I think the point that even in the scenario that you were speaking of, let's say there wasn't an Elvis with a second marriage, but we have a situation where we have a judgment of divorce, and let's say they owned as husband and wife. The judgment of divorce provides that the husband is awarded the property, but it also indicates that the ex-wife is to receive $50,000 upon the sale of that property. That is something that it's not technically a lien against the property, but it's close enough to a lien, because if he sold the house and she didn't get her proceeds, she could come back later saying, you owe me $50,000. And that's on the title company as the dispersing agent to come up with that.
Yeah.
So, I mean, there are lots of different tweaks, and the other one that I would love to mention, because it does happen as much as we don't think it does or think it shouldn't happen, is that we might have property that is in the sole name of one of the spouses, and there's a divorce, and that judgment of divorce actually awards the non-titled spouse the property.
Yeah.
So it does happen.
I think that's great. I'm trying to think of the term that Gail Anderson gave me for the state of Michigan. It's not community property, but it's something like joint asset disbursement state when it comes to divorce. So even though one of the parties may hold that singly in title, in a divorce situation, a portion of that interest may be awarded to the non-titled spouse.
Because it's still seen as a marital asset.
That may be the reference that Gail gave me for that one. But anyway, trust accounts or trust deeds and trust. I know that a lot of folks have their house held in trust, and that person who's running the trust, there may be multiple beneficiaries. In my own situation with my mother's trust, there were 4 beneficiaries, her children, and my brother and sister were the, give me the name.
Successor, trustee.
The trustees for it. So they were the ones who had to sign the documents regarding anything to do with the trust. They were the ones who were authorized to do it. Now, because we have a good relationship, we all were talking about it and saying, yeah, let's do this, or whatever it is. But what document do you need to tell you, as the title company, who has the authority to sell
The
that
certificate
property?
of trust, and then you'd have the powers section that was actually contained within the actual trust agreement.
Okay, repeat that again, if you will.
You have a certificate of trust, and then as part of that document, there's provision in there to reflect the powers section of your actual trust document that says who has the authority
Okay.
to act on behalf of the trust, who the successor trustees might be if your original trustee has passed away.
Yeah. So using my mother's trust as an example, she had a certificate or a trust agreement, right?
Mm-hmm.
And then she had my brother and sister named as those with the authority to act on behalf of the trust. Okay, so that's what we're looking for when it comes to trust agreements.
And the reason that we ask for a certificate of trust is because there's actually a statutory protection in the law that if there is a certificate of trust, for instance, let's take your example for a moment. Let's say we actually didn't have the opportunity to review the trust itself, and the trust actually said that all 4 children were supposed to sign that certificate of trust, but only 2 signed. So if there's a certificate of trust that's on record and it gets filed with the chain of title for that property, that means that your buyer is protected. If it is not, it's protected against those other beneficiaries who are actually supposed to sign off but didn't. So if they came back later saying, well, wait a minute, I didn't agree to that, and I, according to this trust, I was supposed to sign off on that, but I didn't. Well, under the law in the state of Michigan, as long as there's that certificate of trust that's on record, that provides protection for your buyer. Because there are some instances where not all title agencies are requiring certificates of trust. Again, it seems to be the theme here today. It is for the protection of the buyer.
Right. Let's talk a little bit about powers of attorney. I know I get the question a lot, whether a person can sign under a power of attorney either to buy or to sell, and is my understanding correct that it is less likely that a title company is going to accept on the seller's side the power of attorney or on the buyer's side? Which is there a difference there?
We need to know why a power of attorney is needed. There
Okay.
can be perfectly valid reasons why a power of attorney would be used, but we
Okay.
want to know what those reasons are.
Okay. For example, I actually mentioned to you earlier that I got a call over the weekend, I believe, or this morning, I'm not sure. But the question was, seller wants to sell. It's actually the seller's girlfriend wants to sell his property while he's unavailable and won't be available for some time, several months. And, red flags, bells, whistles, all sorts of things started to go off in my head, and I thought, how do I know that the real owner of this property is actually selling it? Maybe he gave her the power of attorney to pay his bills or to refinance his car or something like that, but not to sell his house. How do I know if I get a call like that? What do I do?
Review the power of attorney and the circumstances surrounding it.
Okay, and would it tend to, if it excludes real estate or does not specifically
Then
include it, then the power of attorney does
No,
not.
it's not good for that.
It's not good for that.
Yeah.
Okay.
In my, I guess, opinion, as a title person, the more specific your power of attorney is to your transaction, the better protected
Okay.
the clients are. If I can sell your property within the next 2 weeks. After that, the power of attorney is null and void. It identifies your property description, your street address, and indicates that I would have the power of sale and what to do with the proceeds.
Okay, so if it doesn't have that, as an agent, and we've actually read Schedule B, we ought to be asking that question. Let's see the power of attorney.
Yes.
Give me the power of attorney so we can look it over. Other things that are gonna pop up, and I'm gonna rush a bit here because we're running out of time, but we also run into issues where in the process we discovered that restitution, if a person has committed a crime, is serving time, and owns property, has equity in it, but there is restitution due to a victim, that the state actually has a right to that money in a potential sale. And we've all heard of IRS liens. Do those things tend to come up on Schedule B? Are we aware of them fairly early on in the
In a
transaction?
perfect world, those liens would be of record or judgments against the property. Sometimes they come to the fore as we're realizing that the girlfriend is trying to sell property on behalf of someone who is incarcerated.
Or the wife is trying to sell for the husband who's in jail or in prison. And she's wanting to sign by power of attorney and asking for all the proceeds. So in your situation, it most likely is not going to be on record that that person is incarcerated, and that the state has the right to those proceeds to pay for not only if there's restitution, but also just for their incarceration,
Right.
the cost of their incarceration.
So what happens in a situation where you actually close that transaction and the money, the proceeds have been dispersed, and the state of Michigan comes knocking on the door? What happens, or the IRS, for
It
example?
ends up as a title claim.
It ends up as a title claim.
And
Okay.
potential litigation.
Okay, and yeah, if the title company pays for it, they're gonna go after somebody.
Exactly.
Okay. So again, look into it as deeply as you can. Real quickly, oil and gas agreements, brine wells, fracking, mineral rights, all of those kinds of things. How does a buyer get title insurance, or how do they search to know whether or not the land that they're purchasing has already been leased for the purposes of fracking or oil exploration?
That is a very specialized search.
Very specialized search.
Yes,
Okay.
if we see evidence in the chain of title of a reservation of oil, gas, and mineral rights, we'll cite it, but it's not something that is necessarily a guarantee within your title insurance policy. We take exception to oil, gas, and mineral rights.
Okay, so if it happens to pop up, what should an agent do if they've read the Schedule B?
And are you asking if they want an oil and gas search?
Yeah, if it says that there's an oil and gas lease from 1942.
Again, you'd have to do a very specialized search on that. There are companies that do that. We typically don't.
Okay,
Most title agencies do not. You'd actually have to look for what we call in the industry a landman.
a landman.
Oil
So,
and gas abstractors.
but be aware, especially if you're, there was a sort of a rash of mineral rights being bought up in the 1980s and even into the 1990s along areas of the coast, up along Shelby, Hart, and up in that area, as well as other areas. So if you're working in those areas where oil and gas leases were being purchased for natural gas exploration or oil exploration, be sure you check into it, find out whether or not your seller knows anything about any potential agreements, mineral rights agreements that have been given.
Active leases, active wells.
Active
There's
leases,
a whole
yeah.
body of title law that surrounds minerals.
it's huge.
There's a Dormant Minerals Act in Michigan. There's a lot of things that could impact that, and you really do need the specialized search to know who
Okay,
owns title
same
to
thing
those
holds
minerals.
with easements, right? If recorded easements are going to be
Recorded easements will be reported on your title commitment.
on your Schedule B. But again, if somebody doesn't read the Schedule B, then you're not going to know whether there's a utility easement or potentially a storm drain easement or wetlands area in the back that is
Or if a
protected.
neighbor or some other person has an easement across your land.
Whether they have the right to cross your land to get to their own land. They may have an easement for the corner of their pole barn that sits on your property. So again, if they're recorded, they're going to show up on Schedule B, which is one of the big reasons why it's so important for agents to review the Schedule B and understand it. And if you don't call your title person and get to the bottom of it, just
Absolutely.
don't let it just slide. Non-citizen transactions, what should they watch for? On the seller side and on the buyer side.
Well, if your seller is a non-citizen, they could be subject to a withholding tax. And again, we would need to know all the details of the transaction to give you that amount. There's, I believe, a $300,000 sales price amount in there, but it has to be property that they're going to live in. But again, it's the buyer's responsibility to collect and pay that withholding if it's assessed.
Okay, you got to repeat that one, because that's.
It's a lot of information.
That's a lot of information, and
I have a flyer I'm happy to share with anybody that wants it, that kind of gives you the nutshell version.
If you have
that.
that in a PDF
I
form,
do.
that would be great, and you can load it actually onto this link or get it to Dom, or me, or Mary, and we will load it right in here so that they have that information. There's a lot of, when it comes to title work, it's a really, really, really complex field.
It is.
That's why we encourage agents to read the Schedule B, to understand it. If they don't understand it, to go to people like you to get a clear understanding of what's involved, of what property they're buying or selling. And I can't thank you enough for being here today.
Thank you.
Thank you for having us.
You're
Yes.
very welcome. And next week, 1 o'clock, see ya.